Well, good afternoon, everybody, and good evening and good morning, wherever you may be. Welcome to this year's annual Eric Barendt Law Lecture. My name is Kate O'Regan. I'm the director of the Bonavera Institute of Human Rights, and we're absolutely delighted to be partnering with the Journal of Media Law and the Price Media Moot competition in hosting this lecture today. We're particularly delighted to be joined by Dr. Damien Tambini, who in a former life as the director of the Programme for Comparative Media Law and Policy here in Oxford, was one of the people who actually started the Price Media Moot. So in some ways today that process has come full circle. I also would like to give a very warm welcome to Eric Barendt, who's one of the people who is attending today. And just say a few words about him. So Eric started his academic career here at St. Catherine's College, not very far from Mansfield College in Oxford in 1971. After nearly 20 years here, he moved to the University College London, where he became the Goodman Professor of Media Law. Eric Barendt's name is known to all media lawyers, not only in the UK, but around the world. His groundbreaking book, Freedom of Speech, which was first published in 1985 and then republished again in 2005, has been a source of law to media lawyers all over the world. Not only has Eric Barendt published in this field, though, he's also published on a range of other things, including constitutional law, broadcasting law, academic freedom. So it is really very fitting that this lecture is named after him. In 2009, he was one of the founders of the Journal of Media Law, together with Tom Gibbons and Rachel Crawford-Smith. And it is the Journal of Media Law, as I mentioned, which is co-hosting the lecture today. In addition, however, Eric has been a great mentor of many young scholars and practitioners in the field of media law. And again, that is something that we want to acknowledge in hosting this lecture, his immense intellectual work in this field. So thanks very much for all you've done, Eric. We're delighted to be able to host this lecture in your honor and delighted as well that you can be here today. So just to give you a quick outline of how it's going to work this afternoon, the lecture will last around about 50 minutes and will be followed by Q&A. For those of you who haven't found the Q&A button on Zoom, it's on the bottom right-hand side of your screen, and you just need to enter in your question there, and then I will moderate the questions at the end of the lecture. In addition, following the Q&A, there will be a short vote of thanks by one of the current editors of the Journal of Media Law and one of my colleagues here in Oxford, Jacob Rowbottom. So he'll just speak for a few minutes at the end. So we expect that we will definitely be finished by 3:30 Greenwich Mean Time in about an hour and a half. I would finally like to just welcome all the mooters who are engaged in the Price Media Moot competition this afternoon. We know that many of you have qualified for the finals, which unfortunately we can't host in person in Oxford this year. But we are really delighted to know that you've qualified. We look forward to the final week, which is in the week of the 12th to the 16th of April. I also want to thank many of the people who are here this afternoon who've agreed to judge in the final rounds of the moot. In many ways, the judges are the unsung heroes of the moot because it's a very arduous week for the judges, but it's very important to the mooters that we have really competent people to do the judging. So thanks to all of you who've joined, who are going to be or have previously been judges in the Price Media Moot. So with all those preliminaries aside, I'd like to welcome our lecturer, Damien Tambini, and hand over to him. Welcome, Damien.
Thank you very much, Kate. It's great to be back, as you point out, in Oxford. Very happy about the association with the Programme in Comparative Media Law and Policy, which one of my former stomping grounds, and wonderful to be honoured with lecturing at the Eric Barendt lecture, having relied on his book for so many years. These are really difficult shoes to fill. So at least I hope I give him something to disagree with, if nothing else. I'm going to share my screen, and you bear with me for just one moment. If I actually have the capacity to do this. There we are. Okay, can you all see that?
Yes, we can. Thank you.
So this was originally going to take place during a period when I was finishing my book, the title Media Freedom. And I was hoping to have a chance to have lots of feedback and take it into account. The book has now been finished and it's not yet out. So I look forward to your comments, but I'm afraid I have to say it's too late to actually take them into account. So what I'm going to start with is Jürgen Habermas, who stressed the importance of an independent, self-regulating media system in order to facilitate democratic legitimation. So my starting point here is to ask whether law and policy, and to what extent law and policy, facilitate the independence of the media within the democratic system. And the question I want to pose is to what extent, in order to do this, there should be or is a right of freedom of the media independent and distinct from the right of freedom of expression. So there are some things we can all agree on. So we can agree that recent attacks on journalists, we can think of Jamal Khashoggi and Daphne Caruana Galizia, they require public authorities to protect journalists better. So recent moves to enhance diplomatic and legal protection for journalists are long overdue. And also media law reforms that place news media under any more of a threat of censorship than they're already under must be resisted. But media freedom is more than protection of journalists. It also poses questions for the structural and systemic context of media. Media are undergoing a crisis of sustainability and revenues. Previously, they were able to absorb legal and other risks, and they were able to protect themselves. They were able to protect their fourth estate power, if you like. So I think if we think more systemically about media freedom, it enables us to think about the next generation of democratic media and place this question of media freedom in the context of this current crisis. There are also questions about wider threats to media freedom, the assertion of information sovereignty, new forms of control through fake news laws, and a new generation of European social media controls that involve complex new multi-stakeholder models of co-regulation, which involve public and private governance, which combine software and legal code with self-regulatory codes of conduct. So in all of this, we hear a lot of alarms raised about freedom of expression. For example, whether removal or qualification of liability exemptions would undermine freedom of expression. But what about media freedom? Should social media benefit from media freedoms? Or should they be regulated to protect real media from them? So I was delighted to see that Jan Oster has joined this call. He argues that there is and there should be a fundamental right of media freedom. So on the basis of his really detailed and thorough analysis of comparative law, he demonstrates that freedom of the media should indeed be considered a separate right. Oster, in my view, is less clear about what this right is. He refers to it as a principle of law. And I want to just engage with that later in my talk, what this right is and how such a principle of law, if you like, a design principle, can be brought to bear as media law and media regulation is redesigned in order to protect democratic communication. So the international drumbeat of media freedom, support for media freedom, is louder than ever. So the EU Charter of Fundamental Rights at Article 11 actually mentions media freedom in a somewhat weak way. Freedom and pluralism of the media shall be respected, but it's there in the Charter. The Council of Europe has issued standards and recommendations promoting media freedom, and the UK government recently set up a media freedom panel, which is chaired by the former president of the Supreme Court. The OSCE, the Organization for Security and Cooperation in Europe, maintains a full-time special representative to promote media freedom. And that's not to speak of this alphabet soup of NGOs and IGOs which are promoting media freedom. But there is in all of this significant disagreement in what media freedom actually is. One of the key international tendencies, I would argue, lately, is a divergence, in particular between international human rights approaches to media freedom on the one hand, and US First Amendment approaches on the other. And that's another theme which I'm going to develop later in this talk. So much of US First Amendment jurisprudence argues against special rights for journalism or the media, whereas in the European Court of Human Rights and the international human rights system, there's much more openness to the notion that the law should protect a watchdog media and award special privileges, such as source protection and support for journalism. And as the world, or at least the world's democracies, are seeking new common principles, I would argue that this kind of international divergence is a problem. So I'm going to argue that a new positive notion of media freedom can and should provide a normative beacon around which a renewed politics of media reform and institution building can be organized. But in order to do that, we need to agree what those basic tenets of media freedom are. And as a compromise, we need to find the common elements between these divergent legal and philosophical traditions. So there are 5 parts to this lecture, and the structure is roughly as follows. In the first section, I'm going to mention what I see as some of these contradictions and confusions in current ideas and legal frameworks for media freedom. Then I'm going to ask why this might matter. I'm going to make the case for why it's useful to have a theory of media freedom. I'm going to pick up that point that Jan Oster raises. Then I'm going to present an argument that there are in fact 2 cultures or 2 approaches to media freedom. I'm going to explain why one of them is no longer sustainable, and also pick up why we have these international divergences in approaches to media freedom. What's the history behind that? Then I'm going to outline the elements of what I see as a common theory and apply it to some current debates. So that's quite a lot. So I hope you've got some coffee, and apologies if this is at times dense. So I should point out, just starting, that while this is the Eric Barendt Media Law Lecture, I'm not approaching law as a lawyer would normally approach it. I'm looking at the underlying doctrines, rationales, and normative justifications of media law and their history. And I'm going to introduce a few ways in which my current and recent research and policy work impacts and develops these issues. In this, I'm going to be relying on a number of recent analysis. Oster, I mentioned, Monroe Price, Jackie Harrison and Lorna Woods, Rachel Crawford-Smith, and of course, Eric Barendt himself. So first of all, confusions. in what media freedom might in fact be. My first point is, whilst there's a lot of full-throated support for media freedom, we are living in a period where there is huge contestation at the most fundamental level about media freedom. So let's take as an example the recent spat between Twitter and the former United States president. So it's not clear what Twitter and Facebook's rights of autonomy may be, but the current situation of deplatforming does seem unsustainable to me. It seems constitutionally wrong that a sitting president can be silenced by a private company or a series of private companies operating in concert. Trump, of course, claims that his freedom of speech has been curtailed by Twitter. They suspended his account, citing violation of its glorification of violence policy. In the United States, of course, he cannot successfully assert his speech rights against censorship by Twitter because the First Amendment protects him against censorship by government rather than censorship by Twitter or a private company. On the other hand, the social media platform itself could claim that its editorial decisions would enjoy some protection as speech. So should Twitter's action be regulated, perhaps to promote the speech rights of its users, or should the social platform enjoy autonomy? So this was, after all, a fight that started before the Capitol riot. When Trump, in response to Twitter attaching warnings to his tweets, signed an executive order in May 2020, removing liability protections from social media, Professor Tim Wu, now an advisor to the Biden administration, and of course an expert in the First Amendment, Tim Wu commented that removing liability protections, quote, lit a legal dumpster fire by imposing prior restraint. So he here is invoking the autonomy rights of newspapers or media ultimately for Twitter, suggesting that Twitter enjoys some kind of autonomy. So we have within the US real confusion and potential for protracted conflict over these different interpretations of freedom of speech and freedom of the media. So if the European Court of Human Rights was called upon to adjudicate on the same issue, it's not at all clear it would be any clearer. It has tended to stress the positive obligation on states to protect speech and create the plural environment sufficient for democratic communication. But the status of institutional protection, whether social media have autonomy rights, has not been tested. So the European Union is proposing to introduce a comprehensive new regulatory framework for social media. We'll come to it later. Also in the UK, broadly in line with this, Ofcom will enforce platform responsibilities to reduce online harms and do many other things, including protection of speech rights. And this introduces a new institutional relationship between online platforms, or very large online platforms, as they'll be called in the EU, and governments. So what role might institutional separation play in the new architecture of communication governance? Should institutional rights of the media be a core principle of regulatory reform? And does this apply to social media? From one point of view, social media are being brought into too close a relationship with the state, co-opted to manufacture a state-sanctioned view of reality. Should a principle of autonomy govern those relationships? Is this the same thing as media freedom? And how can this build upon historical, constitutional, and legal ideas of media freedom, this notion of institutional separation of social media and intermediaries? So there are many other questions and debates and confusions around media freedom that I develop more in the book, and we don't have time to go into today. But behind all of these, in many cases, is confusion between freedom of expression and media freedom. And there has, for a very long time now, been a controversy, particularly in the US, about whether media should have specific institutional rights, whether the First Amendment to the US Constitution phrasing "or of the press," does that have any significance? Whether there is a journalistic privilege to protect sources. On institutional rights, there's quite a deep cleavage between the US approach, which denies special rights for the media, and a European and international approach that's more keen on them. And I would argue that this is part of a wider isolationism in the US approach that really should be addressed in the next phase. That there's a view of freedom of speech, US view of freedom of speech, which is also embodied in the large platforms approach to speech. And I think it needs to be unpacked and discussed. So just to wrap up, there are multiple confusions involved in this. Should states support media autonomy? Are they obliged to do so? And of course, the key question, are internet intermediaries, such as Twitter, are they media? So despite the growing array of bodies with responsibilities in the area of media freedom, there's quite a lack of agreement on what it is. Before I go on to attempt to examine some of these confusions in a bit more detail, I want to just pose the question, my second question: does it matter that we have these confusions, in particular about media freedom? And I want to present three main arguments that it does matter, quite fundamentally. Firstly, claims about media freedom are very often used to block media reform. Any attempt to create new interventions, whether that's public funding or subsidy models, spectrum licensing, the design of new competition regimes, all of these will inevitably have the potential to create institutions that could in the future be vectors for state capture of the media. So the international NGOs and IGOs that emerged mainly since the 1990s to protect freedom of expression have done a lot of excellent work to protect the media from state capture. But they're also very often lobbying or engaged against institution building. And this creates a kind of policy stasis, I would argue, at a time when new institutions, new forms of accountability need to be created for the media. There's a separate economic argument about why freedom of the media and confusion about freedom of the media matters. And this draws on institutionalism in economic and political science and theories of punctuated equilibrium in public policy. So when institutions break down and new institutions are being built, ideas matter, including ideas such as media freedom or media autonomy. Currently, multiple actors are engaged in constructing new institutions through automated forms of regulation, self-regulation, and co-regulation embedded in a legal framework, and we'll come to the Digital Services Act. It's important in these multi-stakeholder processes that common principles, common ideas are shared and engaged with and understood. So current proposals for social media regulation raise questions about whether the institutional autonomy of social media should be an objective. And this process of complex multi-stakeholderism, rather than linear lawmaking, this is the process that is rebuilding democratic media systems. Actors need a common theory. In Austin's terms, they need a principle, because this will enable the loose coordination of multiple actors in support of a common normative vision. And another reason why we need a theory of media freedom, the third and final one, is legitimacy. Democratic legitimacy requires a better and more widely agreed constitutionalized understanding of freedom of the media. So in a democracy, the public needs to understand the basic rules of the game. And this includes a publicly accessible, publicly understandable theory about what freedom of speech and media entail. So those lacking faith in democracy increasingly perceive the media, or what you might call the media political complex, as a single blob of conspiracy. So real, demonstrable, justiciable media autonomy and speech freedom are one of the antidotes to democratic despair, and where we see everywhere around the world declining trust in democratic institutions. So a significant body of opinion in the leading democracy on the planet believes that the ex-president has been censored. Many others believes that he has been engaged in censorship of social media. And without common principles, this is deeply problematic for democratic legitimacy. So I would argue that there are a lot of advantages in an analytically coherent theory of media freedom, one that's widely understood, which links not only to the principles underlying media policy, but also media law as it develops. So this is why I agree strongly that we need a principle of media freedom to underpin laws and legal decisions that structure the media. But I do think it needs to be clarified. So John Rawls said that any theory of freedom must specify what is free, what it is free from, and to do what. So media freedom, as currently understood, doesn't really meet this standard. It doesn't really, we don't really have any agreement on even the very basics. So how can we understand the wider legitimacy of such a set of ideas? Is there really any hope for having this as objective of an autonomous system which is trusted and more widely understood? So my proposal is that we need this kind of an intervention at the level of normative theory of media freedom. And to do so, I need to examine the underlying theory and say a little bit about where these confusions originate. So the debate on internet media is a good example to illustrate why this confusion matters. The consolidation of powerful social and search gatekeepers has been the key development on the internet in the last decade, along with a far-reaching debate about the responsibility for those new pseudo-media for the social externalities associated with their use. There are calls for regulation, but also claims that, like the press and broadcasting before them, internet media should benefit from protections and privileges in light of their sensitive democratic function. So this is an idea of content neutrality, as it's called in the US, for internet media. The state should simply get out of the way, hence the concern to protect the regime of liability exemptions, which we find in Article 14 of the E-Commerce Directive and the much debated Section 230 of the Communications Decency Act in the US. Some academic and civil society commentators argue that the liability exemptions and the wider and the wider notion of institutional autonomy should apply, but others argue that they're not in the public interest. In the next section, I just want to examine the background to these ideas. So we can understand this, and I'm moving to my third point now, in terms of what I call two cultures, or two main theories of media freedom. One, which I'll come to, is associated with writers such as Judith Lichtenberg, which is the positive theory, and the other I will call the negative theory. These are familiar distinctions to make in theories of freedom of expression and freedom of the media. I'm certainly not the first to examine these sorts of issues. As well as Judith Lichtenberg, I'll mention the work of Laura Stein, and note that my colleague at LSE, Andrew Scott, and his colleague in Melbourne, Andrew Kenyon, have published an excellent collection on this theoretical distinction between negative theories of freedom of expression in the media and positive theories. So negative theories, first of all, are concerned with freedom from. So liberty is defined as the absence of constraint, particularly constraint by state actors. And this theory argues against specific protection of media freedom. Freedom of expression in the media should be the same, because singling out media for special treatment is only going to lead to manipulation and pressure on the media. So we can see this reasoning in several of the doctrines of the Supreme Court of the United States, for example, on content neutrality, non-discrimination, and non-interference of public authorities in the speech field. And of course, in this principled defense of liability exemptions for platforms. On the other hand, the positive theory is based on identification of the functions and purposes of democratic communication and the notion that special privileges might be necessary to ensure that the media can fulfill them. Empowerment approaches, as they are also called, broadly support a notion that the media should support the democratic discourse and should be privileged in order to do this. And this is Judith Lichtenberg's point here. So what are the positive privileges that media receive? They are varied, and they date back to the very first postal privileges that newspapers, along with tax exemptions that newspapers negotiated for themselves in the early days of the mechanized printing press in the 19th century. Positive privileges also include spectrum subsidies, license fees, public interest defences, source protection for journalists. And in more recent years, prominence and prioritization on social media and smart TV interfaces. So, whilst in practice, most legal traditions combine both positive and negative approaches, I would further claim that the two theories differentiate on the one side the US, which tends to a more negative rights approach, and on the other side, Europe and the international human rights system, which embraces a positive approach. So I would cite UN General Comment 34 from 2011, and also the standards of the Council of Europe, which a positive role for the state in promoting media freedom, media pluralism also, and public broadcasting. This approach is also evident in the important joint statement of the Special Rapporteurs from 2011, which sets out a positive approach to the role of private intermediaries and censorship. So in terms of rules' basic requirements, the two theories have different responses to the three basic questions. For the positive rights theory, responsible democratic institutions should benefit from their privileged position in the light of the important democratic function they serve. Media must be free of the state and also of private power. Negative rights are concerned only with the state. For the positive rights theory, duties and responsibilities attached to discourse in proportion to its social importance, whereas for the negative rights theory, only a basic harm principle restricts speech. So, of course, there are arguments against positive media freedom. A long list of objections to these kinds of interventions to promote the democratic role of the media. It's elitist. It will lead to a slippery slope to censorship. Singling out the media or journalists or news for special treatments makes it more likely that they will be controlled. If public service media are funded, threats of removal of funding can call them to heel. If tax breaks or cheap spectrum are offered in return for socially beneficial journalism or news, then they establish a vector of control. If social media are subject to a code of conduct by the same reasoning, this will lead to government control. In many cases, these principles have been rather accurate. There's a poor record, particularly in transitional countries, where state media have struggled to become independent public service media, for example. So positive approaches to freedom of expression in the media offer opportunities for interference. Even in stable and mature democracies, the temptation for governments to interfere are often too great. So when the UK government, to choose a contemporary example, toys with the idea of parachuting associates and ideologues into management of the independent regulator Ofcom, for example, or to threaten independent media through regulation and funding pressure on the BBC and Channel 4, these are examples of the abuse of these vectors of control. And although the new Labour government was full of the rhetoric of independent regulatory authorities and an independent BBC, it appointed some prominent sympathisers to the most senior posts. So the UK government has a lot to learn or relearn about the importance of executive restraint to media freedom. So these kinds of dangers of slippery slopes to censorship of vectors of control explain why the US parted company with positive rights approaches to broadcasting in the shape of the fairness doctrine. So Monroe Price, last year's lecture, has described how they were used as a vector of threats by the Nixon administration, for example. So the main argument against positive approaches is that they tend to slippery slopes, whether it's taxation or content regulation, for example. The US courts have been strongly against any form of discriminatory taxation applied to the media sector. This is not to say that there are no tax advantages for US media, rather that when asked, the courts are likely to find against them if in any way they discriminate between different forms of content or different outlets, because differential taxation of the press is presumptively unconstitutional. The UK, of course, is considering currently proposals to extend the regime of tax breaks to online newspapers. And in Europe, tax is indispensable and not presumptively in conflict with Article 10. So states might even have positive obligations to ensure media pluralism and a watchdog media through these kinds of interventions. So through the watchdog doctrine, which I'll briefly show you, and through Positive obligations. There are strong reinforcements in the European system for these kinds of positive interventions. There are, of course, a number of arguments against negative freedoms. The most compelling, in my view, is that negative rights approaches are in fact likely to lead to the death of democratic public interest-oriented media. Because particularly in our current market situation, positive interventions are now a necessary condition for democratic media systems. Media, in the sense intended by Habermas, will not exist without positive interventions. Negative rights, of course, may also lead to concentrated, unaccountable media. In the age of powerful AI and data-driven media, it seems to me to be counterintuitive to endorse a doctrine of minimal restraint. Without some forms of interventions and checks and enhanced accountability, we may witness the rise of powerful, unchecked robo-media. Think back to a few years ago, and this is some research I was involved in just after the 2017 election. Then we were shocked and surprised by the deployment of new forms of social media advertising during elections, the lack of transparency, the lack of accountability, the ability to breach existing checks and regulations around spending and data consent, for example. So this was some very fast kind of emergency research we were doing just to try and find out what was going on during that period. I think we'll see similar debates around new forms of media, that with the combination of increasing concentration of media and the incorporation of data-driven AI technologies to target media, the usual conditions of transparency and existing restraint of media power simply will not work. So, to recap, so I've gone the wrong way there. I've argued that there are unresolved confusions about concepts of media freedom and freedom of expression, and I've argued that it matters for practical reasons of legitimacy and policy. And I've pointed out that there are these two underlying philosophies of positive and negative rights. It may be pointed out, of course, that my advocating of positive rights and really trying to bring together those two approaches will not wash with American defenders of the First Amendment. But my argument is that without positive rights approaches, it may not be possible to sustain media as required by democratic legitimacy. And I think it's dawning on many people that, given the current crisis of the media, new forms of policy intervention, including positive supports for the media, are necessary. And I would also point out that it's not in fact true that positive approaches are entirely foreign to the US. The US did sustain the fairness doctrine in broadcasting for close to half a century. And there has always been this tension between these different interpretations of the First Amendment. So I'm arguing that the negative rights theory in its most extreme form is doomed. In a world in which everything and potentially everyone is media, we need positive interventions to create a privileged space of responsible, truth-seeking, public-interested media. Without active socio-legal construction, it will not exist. So I'm going to mention just in passing some recent work I did on new forms of positive intervention. I should mention my PhD student, Eleonora Mazzoli, with whom I collaborated on this work in the context of the Council of Europe. And the report on the right there is a discussion of new forms of prioritization. So in smart TV, but also social media interfaces, which are increasingly prioritizing content, including media content, they are providing positive support for media. And there's a very vibrant debate currently at the European level about the extent to which they should be regulated so to do. Should there be regulations to promote prominence and discoverability of media? But before I go on to the current policy framework, and I think I'm going to need to speed up a little bit and wrap up, I just want to mention just a couple of things about the history of why we have these two cultures of media freedom and the origin of the negative rights approach in particular. So in order to avoid what I see as a kind of mystical originalism, we need to ask where these theories come from. Many people see the positive rights and negative rights opposition as a projection of a kind of left-right distinction. But it's really not as simple as that. And in my book, I develop quite a lot of historical analysis of the emergence of these ideas. Historians of the media, such as Paul Starr and others, and legal scholars trace these two views to the context in which they emerge. In the US case, that means the American Revolution. And the revolution against the English state emphasized freedom from law. And it was particularly out of frustration with British censorship, and in particular taxation, that these ideas of content discrimination and the particular rejection of media taxes emerged. They also emerged, these first more negative ideas of press freedom in the press era. There was a notion of that this was a concern with the printing press and licensing of presses in particular. By contrast, the international human rights approach was set out in the immediate post-war period, mindful of the fragility of European democracy and the despotic possibilities of broadcasting and the industrialized press. So the European approach explicitly permitted licensing of the new medium of broadcasting and the emergence of a dual system of broadcasting. So in developing these two theories, I've somewhat caricatured, but I think the basic distinction holds up. And I think that very often a lot of the discussions we have in media law and policy, when we're confronting these choices about which institutions to build, can be understood in terms of these two opposing arguments. So I should come now to my theory, and I have to disappoint you and say I'm not going to give the whole thing. You have to go to my book for that. A lot of these theories, and Jan has, I think, 9 principles. I've got 10. I'm going to deal with 3 or so of them. We might get on to a couple more. Before I get on to the main principles, I think we need to set out the basic philosophical justification. So freedom of expression is a human right. Freedom of the media is clearly not a human right. Media are not humans. And as such, and this is fairly well established, freedom of the media does not benefit from arguments from human autonomy. So we can see this in Honora O'Neill's work, for example. media freedom is more tied up with the role of the media in democratic societies and the social value of truth. So media freedom is both institutional, concerns the media as an institution, and it's instrumental. Media freedom is a means to other goods. And that's important when it comes to thinking about the structures and frameworks for governing media freedom. So I argue that there should be, under certain conditions, a principle or a right to media freedom. The positive theory that I would advance needs to be also mindful of those objections, those slippery slope arguments which are raised by the negative point of view. Fundamentally, media freedom is institutional and instrumental, and it needs to be, in my view, a more pragmatic and realistic theory, which focuses on the procedural level of the governance framework, and I'll come to what I mean by that shortly. So, sorry, I went backwards there. The elements of the theory. First of all, what are the media? This is the key question, isn't it? If media freedom is a right, what are the media? Are social media for the purposes of media freedom? So, in my proposal, media freedom is not restricted to traditional media, such as the press and broadcasters. Neither is it available to any bottleneck in information distribution. Media should be defined functionally in relation to public interest-oriented journalism, in terms of size, and through self-declaration. And there are many ways in which current European policy reflects these principles. They must be free from the state, but also from private control. We need to learn from the problems of the last century of the way media power was governed, that a lot of the controls and compromises of media freedom come from private actors as much as from states. So these are quite familiar points, but I think they need to be renewed in the context of the debate about the Digital Services Act and other new interventions in Europe. And what should the media be free to do? Media freedom is not absolute. It is curtailed by other rights and the rights of others, and by the public interest as defined by the public. So in this theory, I agree with commentators such as Victor Pickard that there needs to be a new social contract for the media. The approach should involve a positive rights approach, including a new deal on competition. How big should media companies be permitted to be, and arrange across all of the other privileges, positive privileges, which must be awarded openly and transparently, and not in ad hoc backroom deals. So the point in all of this is that it's the substantive detail. It's not the substantive detail of the rule, such as a prohibition on discriminatory tax, the idea of content neutrality. That is less important than the question of who is exercising the discretion and the procedural conditions of independence and transparency with which these rules are implemented. And just to mention another piece of work on the left here, I'm doing within the Council of Europe, along with colleagues such as Manuel Pupis and Mark Cole and Maria Donda from Ofcom. We're trying to set out some standards for media governance. This is the MSI Ref Committee of the Council of Europe. And these standards refer to general principles of procedure and transparency and accountability to civil society for taking media governance decisions, whether they are to do with spectrum, to do with intellectual property, to do with distribution, or indeed provenance. And those decisions should be made according to a set of procedural standards which this work is setting out. So just to sum up and conclude, governance arrangements of democratic media systems are being updated currently through an interlocked series of policy decisions. I would argue that media freedom should be a key principle in this process of policy change and in the application of media law, because autonomous media institutions that are self-regulating and observe an ethics of truth are required by democratic media systems. Media freedom is embraced as a value, as we've seen globally, but there is a huge amount of confusion about media freedom and about the basic issue of what and who should be considered media. I've argued that this matters, particularly in multi-stakeholder, automated self and co-regulation, because a common idea of media freedom would be immensely helpful in developing those new policy and governance frameworks. I described two theories, and I explained why the positive approach rather than negative approach was an appropriate framework, because the negative rights approach is clearly unsustainable and unsuitable in the current environment in which media institutions need to be created, because everything is mediated. So, in closing, I just want to note that the direction of European and UK policy is towards such a view. So we could speak, for example, about the new Digital Services Act, which establishes 4 categories of online platforms, and it sets out a set of obligations and a sliding scale, including potentially a set of principles which will oblige them to prioritize certain forms of media and engage with fact-checking independently. These new policy frameworks that we can come back to in the discussion, I would argue, and also the Online Harms Bill, which is the UK equivalent, do provide some of these positive supports for media. They do promise in some ways to provide for a positive notion of media freedom. And I would argue that the focus that we need to maintain as we discuss these new frameworks is on this procedural dimension and the question of independence in policy making. And just as a closing point, my favorite clause of the Digital Services Act is the clause which underlines a really strong support for media freedom, and particularly for independent regulation. So the digital services coordinators in the UK, if it was still in the EU, this would mean Ofcom, or the Ofcom equivalent in EU states, has to be entirely independent from the state and other actors, including private parties. So there's a huge importance given here to the independence of the regulatory authorities as a means to protecting the autonomy of the media actors themselves as platforms for speech. So I think I've run out of time, and I'm going to stop there so we have some time for discussion. But I want to finish with Eric Barendt, who famously pointed out that the media have a lot of skin in the game in these debates. And a lot of the work of academics and others in researching these kinds of areas is to try and get beyond a lot of the self-interested arguments promoted in terms of, as a means to try and capture debates on freedom of the press. I hope I've succeeded in taking a few small steps in that direction today, and thank you very much for your attention.
Well, thanks very much indeed, Damien, for a fascinating kind of